Good afternoon and welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today we're talking about divorce, pensions, and double dipping. This topic can get a little complex and often befuddles even attorneys working on divorce cases, so bear with me. The Pennsylvania Superior Court, in a case called Hess v. Hess, just recently held, and by held that means ruled, as follows, quote, "The trial court acted within its discretion by declining to include the husband's pension, which was marital property subject to equitable distribution, in the husband's amount of income calculation when making the equitable distribution determination in Section 23, Title 23, Section 3502A, because the trial court analogously characterized the master's inclusion of the husband's pension in the husband's amount of income calculation to be a type of double dipping," end quote. So is that clear? Easy to follow? Of course not. So let's break it down and try to make it more easy to understand. First, upon the filing of a divorce complaint that includes a claim for what is referred to as equitable distribution, the court has the power to distribute the assets and debts of the married couple before it permits them to be divorced. A divorcing couple with assets and debts is like a business partnership in which the partners can no longer get along, and so the partnership assets and debts need to be identified, valued, and distributed as part of the partnership dissolution process. It's very similar in a divorce. Now, the more assets and debts the married couple have, the more complicated the divorce. A large asset in many divorce cases is the pension. Now, in the Hess case, the husband had a pension. Legally, he owns it. But because he acquired it during his marriage, it's considered a marital asset, and his wife now has some interest in it because they're divorcing. So wife's interest must be identified and valued in the divorce case. In a divorce master, and the divorce master is appointed by the trial court judge to preside over equitable distribution. A divorce master could award wife a portion of husband's pension, and in the Hess case, did just that. Now, the husband's pension in the Hess case was in pay status at the time of the divorce. He was receiving a pension payment of $1,000 per month, and that's an important factor, and you'll find out why in just a minute. Now, after a hearing on equitable distribution, the divorce master awarded wife 53% and husband 47% of the marital assets and split the husband's pension equally 50-50. So a 50-50 split on husband's pension, and overall 53% to wife and only 47% of the marital assets to husband. Husband, of course, was not happy with this recommendation by the divorce master and filed exceptions to the trial court. That's how a litigant before a master gets the case up to the judge presiding over the master. The trial court granted husband's exceptions, agreed with the husband, and ordered an overall 55-45 equitable distribution in favor of husband. So the trial court swung it the other way and even more toward husband. And as to the pension, a 65-35 division of the pension in favor of husband. So that's a pretty big swing in husband's favor. That's a big change by the trial court. The wife, of course, then appealed to the Superior Court. The Superior Court affirmed, and that means agreed with, the trial court's decision to give husband 65% of his pension. Why? Well, the Superior Court pointed out that the master had already considered the $1,000 monthly pension payment in husband's amount of income and then determined a percentage of awards of all of the assets based upon husband's amount of income, and then also awarded wife a part of the pension that was producing the amount of the income. The court said that was double dipping and not permitted. The Superior Court said the divorce master should not have awarded wife both a part of husband's pension plus a larger part of the assets because husband had greater income due to the monthly pension payments. The trial court and Superior Court said you cannot consider husband's pension income twice. And so the trial court reallocated the division of the pension to give husband the 65% instead of the 50% of his own pension. The Superior Court agreed with the trial court. So that's double dipping in its application in a divorce case. But the interesting part of this divorce case is that the courts used the anti-double dipping rule that had always been used in support cases. So the divorce court took and used a rule that had heretofore only been used in support cases. So now, in light of this ruling, divorce attorneys will examine and consider more closely the anti-double dipping rule we use in support cases when considering the division of assets and debts in divorce cases. Hopefully that's clear to you. It is a complex issue. If you have any questions about pensions or divorces or double dipping or support, feel free to contact one of the attorneys at Scaringi Law at 717-657-7770. Well, that's all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.